Mary, it's great to have you with us. I'll introduce Mary. I also have along with me on my team, Ryan Anderson, who's our outreach manager, and David Singer, who's our sales manager out in Massachusetts, where I think he is about to go out and shovel about 4 or 5 inches of snow. So glad we're not there. I'm sorry, but snow in April is never good. Anyway, we want to welcome everyone today. Today is National Healthcare Decisions Day, and we're so proud to have Mary here with us today. Today's a day that was created to inspire, educate, and empower the public and providers like Kendal at Home about the importance of advanced care planning. One important part of that planning is to think about planning your estate or to revisit the plans you may already have in place. And we're going to talk a little bit about the importance of that and ask Mary a few questions around that area as well. So we're hosting a series of estate planning sessions, which we hope you'll find helpful. In addition to today's seminar, and Ryan will remind us all about this at the end again, we have Attorney Mary Schmidt with us today from Massachusetts. And we're also hosting a 3-part series with an Ohio State attorney that will begin on April 22nd. So it's my pleasure to welcome Mary Schmidt. She's a native of Missouri, but I think she's been in Boston long enough that it almost feels like she's a native Bostonian. She's been there for almost 50 years, I think, Mary, right?
Right.
And she's had a broad range of experience in trust and estate. So we hope that you'll find her insights helpful today. I find her entertaining, if nothing else. So it's great to have you with us.
Thank you.
I think that I have it set up so people are going to see the speaker, but if not, if you're an attendee today and you go up to the top right-hand corner, you should be able to put your computer in speaker view and you'll see Mary. The rest of us will turn our cameras off and mute ourselves so that we're not distracting to your presentation. But if people want to ask questions, I encourage you to type them in the Q&A. You can also type them in the chat. And Ryan and David and I are going to monitor that. So Mary, when it seems appropriate, we'll interject with any questions anyone has related to that topic. And we'll also allow time at the end for any questions that anyone has. So Mary, welcome. And I'm going to turn the program over to you at this point.
Thank you, Lynn.
You're welcome.
So today, I think it's very appropriate that we direct our attention to issues that you need to think about when you are well, when you are competent, and when you are willing to consider alternatives available to you and make some decisions. And those decisions can be made in conjunction with your medical advisors, your family members, your estate planning lawyer, your accountant, and perhaps your financial planner or your wealth advisor. The issues that I want to discuss today include who will make financial decisions on your behalf if you are no longer competent. Who will make medical decisions on your behalf if you are no longer able to make those decisions? And how will your medical decision maker access your healthcare records and your physician in order to make a proper decision? How will your medical decision maker know what your wishes are, your preferences? How will your assets be distributed after your death? Who will administer your estate? Who will be in charge of distributing your assets after you're gone? What is probate? Which of your assets will be subject to probate after your death? And finally, what taxes will be payable on your death? So I'd like to start with the incapacity issues. It's obvious, if you think about it, that decisions have to be made about you and about your finances, whether or not you have mental competency. And at the present time, you are capable of making those decisions for yourself. But at some point, it could be sudden or it could be gradual. You will no longer be able to make those decisions. So to plan for this, the first document or instrument you need is a durable power of attorney. And that is a document that you put in place in which you name a trusted individual or an institution to make financial decisions on your behalf for your benefit. This document, this is the most important thing I'm going to say about this document. This document in Massachusetts is immediately effective upon your signing it. The person to whom you have given this power can access your bank accounts and your investment accounts and make any financial decision, sign a deed, sell, buy, do all those things immediately. It is not a springing power. It does not come into being upon your incapacity. So this is a very, very significant measure of trust. You're reposing either in another person or an institution. And if you fail to do this, a proceeding in court can be initiated in which a judge appoints a conservator to manage your financial affairs for you, so that at no point would you not be cared for financially. The other possibility that you have, and it can be in conjunction with a durable power, is to have a revocable trust in which you have assets during your life and that trustee can take care of you. And these two remedies are not mutually exclusive. Many people have both a durable power for assets in their own name, and they have their own revocable trust, and they put assets in there, and the trustee, in the event of incapacity, can care for you. Medical decisions can be made on your behalf in Massachusetts under a healthcare proxy. And the person named in that instrument is the proxy holder. It's a proxy. It is not a directive. We have in Massachusetts the ability to name someone whom only on the event of incapacity can act. So there has to be a threshold determination that you are not competent to make your own healthcare decisions, and then the agent can come forward and make those decisions for you. And that agent is to use the agent's best judgment to do what you would have wanted to do. Now, many states use medical directives and a living will in the case of final illness. In Massachusetts, those are not binding, but they are very helpful. We do encourage people to have a medical directive and or a living will that communicates your wishes to your healthcare agent. But of course, you're not limited to that form of communication. You can write a memo or a note or a letter or have a conversation with the person that you name, so that that person knows in different situations what you would want to happen, whether you want artificial feeding, whether you want to be put on a ventilator or you don't. Those things have to be communicated. The healthcare proxy in Massachusetts, you are allowed to have a successor named on the proxy. so that if the first named agent is unavailable, the healthcare provider can rely on the second named agent. You cannot, in Massachusetts, merely select someone to be your healthcare agent and keep it a secret. A healthcare proxy is not valid in Massachusetts unless it is signed by the nominated agent, showing that the agent accepted this and is willing to act on your behalf in this way. The healthcare agent really cannot make the best decisions unless that agent has the access to your health records and your physician, your primary physician and other physicians whom experts you've consulted. So you need one more piece of paper, and that's called a Hipaa Authorization. This is based on federal law. It's the Health Insurance Portability and Accountability Act of 1996. And with that, the healthcare agent can then access your medical records and your physicians, your treaters. So in every case, our clients have a durable power, a healthcare proxy, usually a medical directive and a living will, and a Hipaa authorization under federal law. Every client also has a will, and this will serve several purposes. Of course, it directs the disposition of your assets upon your death. It determines to whom and in what proportions or amounts assets are going to go outright to named individuals. And if those individuals do not survive you, it says what happens in that case too, gives a backup plan. It also nominates the person who will administer your estate. And in Massachusetts, that individual or institution is known as the personal representative. And the will can nominate a personal representative and a backup successor. It also permits this person to serve without a surety bond. It has a tax allocation clause, which may differ from our state tax allocation statute. And that tax is the estate tax. And I'll discuss the estate tax more later, but it may be that you want to give certain property to certain people or class of people without their owing any tax. And all the taxes and debts and expenses will be paid by the individual or individuals who receive the residue of your estate. So in the tax allocation clause, you can determine that. And you can also determine if you want a life insurance beneficiary to pay tax on the proceeds of the policy. You can deal very flexibly, can be customized, who will owe the tax. And I'll talk about the tax in a minute. If by chance you do not leave a will, every state has an intestacy statute, and that is basically your state's estate plan for you. And under that, you cannot disinherit people who are the closest next of kin to you. It will go a certain way. So much to the spouse, so much to children. If there are no spouse and no children in Massachusetts, it goes up to your parents. So you cannot disinherit people, you cannot choose the percentages, and the tax is fixed by a state tax allocation statute. That is pretty much to be avoided at all costs. And so that's the reason that most people, if they don't do anything else, they have a will to avoid that. If the person making the will has young children, the will can name the guardian. And this can be important in the case of divorced parents. And in all cases, if there is a child under the age of 18, the will should name a guardian. Your will is a public record. It's in Massachusetts, it's filed in the Registry of Probate for your county, and anybody can go see it, including newspaper reporters or anybody. The Internal Revenue Code imposes personal liability on the individual or institution administering your estate. So if you're asking someone to be your personal representative, they might ask you, are all your taxes up to date? Your gift taxes, your income taxes, your payroll taxes, all taxes, because that is a huge responsibility that is imposed by statute on the personal representative. Most of our clients create a memorandum, and this memorandum details whom should receive their tangible personal property, their furnishings, their artwork, their automobiles, their collections. This memorandum can be changed over and over and reviewed and amended without going back to your estate planning lawyer. However, it is not binding. Because it's not in a will, it's not binding. So you're basically trusting the personal representative to follow your wishes. And that also can extend to saying who's going to pay the shipping, the storage, all that sort of thing. That can be in the will. And then in your memo, you can keep changing. And if you buy a valuable piece of art, you can add it to your memo. If you sell one or it's stolen, you remove it from the memo so that everyone won't be looking for the ring that you always wore. I have many, many instances of this over the years where people did not update their memos and the family was on a hunt for an item which could not be found. So that's the only downside to a memo. You have to keep it current. The next document is a revocable trust. And a revocable trust is a trust you establish during your lifetime. It's not a trust under will. It's a separate document. And this document is not public. So if after your passing, they read the will and the will says, I leave the residue of my estate to my revocable trust, that's all the public can see. They don't know what happens afterwards. A revocable trust can be used, as I said before, to protect you during your lifetime financially. Someone takes care of you. And at your death in the revocable trust, you can just say it goes outright. You don't have to have a continuing trust set up under your revocable trust document. Many people do wish to have a revocable trust become irrevocable on their death and to continue for the future, for a spouse or children or grandchildren or charity. The revocable trust can be amended and can be revoked. And if you named a trustee in it that you don't like anymore or predeceased you, you can certainly change that aspect as well. Many people, as they get older, retitle their assets into the name of their revocable trust to avoid probate. And I will discuss probate in a moment, but people put marketable securities, cash, even real estate in their revocable trusts so that it will be a seamless transition if they become incompetent or upon their death. And for couples, it is my rule to always have 2 revocable trusts, 1 for each member of the couple. And there's an interesting thing about this in estate planning. Sometimes the 2 parties husband and wife come in and they want their property to go different ways at the death of the survivor of them. And that I call the roulette effect, because if the one party survives, all the property of both of them will go to the left. And if the other party survives, all the property of both of them will go to the right. So it's very important that they reach an agreement and have the same disposition in both revocable trusts on the death of the survivor, so that you avoid this roulette effect. And this is generally done through percentages. Assets in a revocable trust are still taxable on death. A revocable trust does not provide any estate tax protection, only irrevocable trusts. If you title assets in the trust, like marketable securities, the income on those assets goes right onto your tax return during your life. It is not a separate taxable entity because you have the right to amend or revoke it during your lifetime. Similarly, a revocable trust does not provide any creditor protection during your life. If you hit a pedestrian and you get sued, any assets in your revocable trust are reachable. In order to have creditor protection, it's very difficult in Massachusetts to have creditor protection. But without going into it too much, I will say it needs to be in an irrevocable trust, and possibly an irrevocable trust cited in another jurisdiction that has greater creditor protection, such as South Dakota or Delaware. The assets in the trust are going to pass at your death according to the terms of your trust, not your will. And the trust also can contain a tax allocation clause that tells the trustee which taxes to pay from which group of assets that are held in the trust. And you can almost think of taxes as a negative bequest. Somebody has to pay the taxes, and you need to think through very carefully which beneficiary or beneficiaries are going to pay the taxes, and make sure that the tax allocation clause matches that. Now, both federally and in Massachusetts, there are no taxes on the death of a spouse if the property is left in a qualifying way. So it's not so much on the first death. The tax allocation clause really becomes important on the second death, if it's a married couple, or on the first death, if it's a single person. Terms of the revocable trust are confidential and not available for public scrutiny. Now I want to explain the difference between probate and non-probate. The only assets that are subject to probate are assets which are titled in the decedent's sole name at the moment of death. So that would be a checking account in the decedent's sole name. A checking account that's joint will pass to the surviving joint owner by operation of law. But those assets are also available to the surviving joint owner generally during lifetime. So probate is a mechanism to determine who gets this asset upon your death, and assures that the person who gets it has good title to the asset, including real estate. So of course, everything in your own name is subject to estate tax on your death. So anything that passes through probate is subject to estate tax. Of course, there are charitable deduction, marital deduction, but they're subject to estate tax. The probate process is public. Anybody can go to the probate court in your county and see what you had, and as I said, to whom it's passing. Another aspect of the probate process is that it gives notice to creditors, potential creditors, because a notice of the probate petition to appoint the personal representative is published in a newspaper in Massachusetts in your locality. So that gives the creditors the right to bring claims against your estate. And also the Division of Medical Assistance, or Medicaid. In Massachusetts, we must send a copy of the probate petition to the Division of Medical Assistance so that they can recoup medical payments made through Medicaid for the decedent's behalf. Examples of non-probate assets are familiar to all of you, I'm sure. Life insurance policies that have a beneficiary, joint bank accounts, retirement assets with a named beneficiary. And generally those assets become available to the recipient by providing a death certificate to the custodian of the asset. Anything that's in your revocable trust will pass according to the terms of the trust through the hands of the trustee, who must follow the terms of the trust in administering those assets. There is a creditor's claims period in most jurisdictions of 1 year. And so it is common for the beneficiary or the recipient not to receive the asset for 1 year until the creditor's claims period has passed. And then either the personal representative or the trustee will transfer the asset. Now, there are two types of estate taxes generally that are applicable. There's the state estate tax and the federal estate tax. Every state does not have an estate tax any longer, but Massachusetts does. Massachusetts and federal estate taxes are due 9 months after death. They can be filed before and prepaid, but they must be paid by 9 months unless there is an extension of time. And generally, one does not get an extension of time to pay, but only an extension of time to file the return. So during that 9-month period, the personal representative and the trustee need to marshal all of the assets and calculate the tax. Massachusetts has a $1 million estate tax exemption, which disappears at $1,000,001. So if the decedent's estate is $1,000,001, it's taxable from the first dollar. This is sort of mind-boggling, quite frankly, but it is our law. So it is the reason that many people who are married have a trust of $1 million for the spouse or the spouse and lineal descendants, and the rest simply goes to the spouse. So the first $1 million is put into a trust, which can be subject to the exemption, and the rest goes to the spouse, which is protected by the marital deduction. So that's a common estate plan in Massachusetts. The trust is known as a bypass trust, and it is not taxed on the death of the surviving spouse, whereas the marital portion will be taxed on the spouse's death. They call it a marital deduction. It's really a marital deferral. It will be taxed. Our mass tax begins at 5% and goes to 16%. It hits 16% at 10 million taxable. If someone is a non-resident and owns real or tangible property in Massachusetts, Massachusetts can and does tax that amount for a non-resident. So the non-resident who lives in New Hampshire has to pay tax to Massachusetts for their Cape Cod house and the furnishings. Massachusetts does not start that at the 5% bracket. Instead, Massachusetts creates a fraction for a non-resident and puts the value of the Massachusetts property over the whole estate, and then collects tax for the pro rata portion of the estate as if the person were a Mass resident. The purpose here is to boost the Massachusetts assets up in the bracket so that the non-resident does not get the advantage of the lowest brackets, but instead it's boosted up. And many people don't recognize that, and they've left Massachusetts. Well, they think they've left Massachusetts, but they leave a house here, they move to Florida. Florida has no estate tax, and so it's a little surprising to them when, in order for someone to sell the Massachusetts residence, they have to pay the Mass estate tax, get a discharge of the lien, and then they have good title and they can sell it. And if there is a desire to have an early sale, people prepay the Mass estate tax before 9 months to get the release. It's very tricky. There are certain ways that non-residents can escape Massachusetts tax by wrapping their real estate and contents in a limited liability corporation or a partnership, but Massachusetts looks through it unless there is a business purpose for that entity. And generally they expect to see tax returns, income tax returns having been filed by the entity during the lifetime of the decedent. So that's a very hard test to pass. I should also say that when people try to leave Massachusetts, if they leave behind a valuable house and valuable contents, very often Massachusetts will launch a domicile battle on the death of that decedent and try to collect back income taxes and a lot of things. So that's a whole subject in itself. But Massachusetts is very aggressive about people saying they're non-residents. The federal estate taxes are not as much of an issue currently because the exemption is $11.7 million per person. That exemption can be used during lifetime for gifts or at death or in combination. That exemption has increased a lot since Trump took office, and Bernie Sanders has filed legislation to bring it down to 3.5 million. If that legislation passes or other legislation like it, it will likely be effective next year. So for decedents dying this year, it'll be okay if you made gifts up to 11 million, or if you die this year and you have an $11.7 million estate. The spouse gets the same amount. So you can see it's 23,400,000 for a couple. And there's something called portability, which means if the first spouse didn't use all the exemption, the second spouse is, under certain circumstances, can use it. The feds also have a gift tax. So anything above $15,000 a year to an individual, you need to file a gift tax return the next April and use up part of your $11.7 million exemption. And if you use it during life, then it's not fully available at death. The benefit to lifetime giving is that the appreciation on the asset from the date of the gift to the date of death escapes estate tax. The downside of lifetime giving is that the recipient, the donee, receives the income tax basis of the donor. So if you have a stock that you paid $10 for and it's worth $100, when the recipient sells it, the capital gain is calculated from $10, not from 100. If it passes through your estate, it gets an increased basis to the date of death. So you have to always balance when you're deciding whether to make substantial lifetime gifts, whether there's a lot of built-in gain or whether there will be a lot of appreciation between the date of the gift and the date of death. And those considerations are very personalized, and the accountant, usually there's a team that gets in on the gifting decision, and that includes the investment advisor, the accountant, and the lawyer. Massachusetts does not have a gift tax. Any gifts made by Massachusetts residents to people during their lifetime will not be taxed by Massachusetts. As I said, gift tax returns are due annually for any gifts made for that year, and they're to be filed in April of the following year when the income tax returns are also filed.
Mary, while you're on that topic, I wonder if I could just interject a quick question around that. So the gift tax, that's if they're giving a gift to an individual, right? In many cases, I know, people are making philanthropic donations. How does that come into play?
The philanthropic donation, whether lifetime or death, if it qualifies, because it's a recognized charity or in certain circumstances, private foundations, that gets a charitable deduction. And there's an estate tax charitable deduction and a gift tax charitable deduction. So that gift it not only does not cause the donor to have a tax, but it actually gets a deduction for the donor, either on the estate tax return or the gift tax return for that year. There are certain limitations. You can't give away your entire income in a year and get a deduction for it, but subject to those limits, and if you give away too much, you get a carry forward that you can use in future years.
Okay, great.
So
thank you.
in making those gifts, you really want to work with your accountant who's keeping good records as to where you are on your charitable deductions. So and that charitable deductions are the reason for the most popular type of irrevocable trust that I see, which is a charitable remainder uni trust or a charitable remainder, a charitable annuity trust, which people make during their lives irrevocably, and they get an immediate income tax deduction. So that's kind of beyond the scope of this basic thing, but charitable planning is one of the greatest things that trust and estates lawyers and accountants get to participate in.
Right.
And we, of course, encourage it. And if it's in your will, you can change your will all the way up to your date of death, change the charities. If it's in your Rev Trust, you can change those charities right up to the date of death.
Great. Mary, can you move your camera down again?
Well, I hate
it seems to maybe a little more. There you go.
A total slippery thing. Now it's too much, right?
No, it's the more you go down, the better, I think. There you go.
Really? Okay. See, I don't see the same thing you do. Okay.
Oh, that's perfect.
Thank you.
You're
okay.
welcome. Thank you. Thanks for that answering that question. That's really helpful.
Now on the estate taxes and gift taxes, once you get into taxable land, which is above 11.7 million, it's a flat 40% tax. Sanders would raise the tax, so in some cases it would get up to 65%. And his exemption is 3.5 million. So many people are calling and getting in touch with their accountants and estate planners to make their gifts this year, because there will be no clawback. And those gifts will, even if they're at 40%, it's still better than 65%. So and the gifts, the lifetime gifts, which are now $15,000 to every person you give it to, every person, Sanders legislation would limit it to two $10,000 gifts annually. And after that, they would be taxable, subject to tax. So there is a huge incentive to making gifts before the end of the year. And while we're on the subject of gifts, there are grandparents who want to make gifts to their grandchildren. The grandchildren or great nieces and nephews are known as skip persons. And so the federal government has a generation skipping tax, which is also 40% and which also has an $11.7 million exemption. So you may use up two exemptions in making a gift, a taxable gift to a grandchild. But again, even if it's taxable, it's 40% instead of 65%. And that only happens after you've given away $11.7 million. Massachusetts does not have a generation skipping tax. The last topic that I'm going to discuss formally is the cost of estate planning. Estate planning can be done two ways. It can be done for a fixed fee or it can be done on an hourly rate. Typically, the fixed fee is for very simple estate plans, a will, a trust, a power of attorney, healthcare proxy, Hipaa authorization, and a summary letter. That's a very plain vanilla estate plan, and most estate planners will do that for a flat fee. But when you get into tailored revocable trusts, you get into any irrevocable trust, you get into charitable planning, that is basically on an hourly rate. And in Massachusetts, it really depends where your estate planner is located, because the overhead for Boston estate planners is much higher than for estate planners in Springfield. So if people wonder why certain lawyers are so expensive, the reason is that they have a very high overhead, and like any business, it's sort of our rent, except it's more than rent, it's everything. And we pay our lawyers who work for us more than the Springfield firms pay their lawyers. So what most people try to do is ask for an estimate at the beginning. And I'm willing to give estimates. I think most estate planners are, but only after hearing some of the facts of the particular situation, so that we can get an idea of what documents will be required, how many conversations, how many emails will be required. And the last thing I'll say is that there is one free thing in estate planning, and that free benefit is if the client names a trust company as their trustee or their personal representative. That trust company will do a free review of the documents after the estate planner drafts them, basically to make sure that they're willing to serve under them, but also it is a protection to the client in case the estate planner made a mistake. So that's, you of course are paying the trust company once the estate plan is put into action, but you do get a free benefit up front. Okay, that's all I have. I'm happy to take questions.
Mary, I wondered if you could speak to this. I find that, so many of our clients, they already have their advance directives in place. They've done their estate planning, but many of them did them years ago and haven't updated them in quite some time. What do you recommend? How often should someone be reviewing these things with their attorney and updating things? I know the laws change, and oftentimes people have designated power of attorney to someone, and maybe that should have been changed somewhere along the way for one reason or another. Maybe that person can't carry those things out any longer. What are your recommendations about how often someone should be addressing those kinds of things?
Well, anytime there's a trigger event. A trigger event might be an illness, a change in your status, trying to be diplomatic, marriage, divorce, that sort of thing, of course, you need to do it. Other than that, I think it's nice to look over one's finances once a year at the same date every year. And at that same time, just to look at your documents and make sure that you aren't surprised by a decision you made, as you say, in the past. Sometimes people move away, sometimes they become incompetent. You've named them in very important fiduciary positions. And it isn't even bad to call them up and say, are you still willing to do this? You agreed to this 3 years ago. Are you still willing to take this on? So probably once a year without outsiders looking at it. But when you get past 3 years, you probably should have somebody else look at it, whether the accountant, the lawyer, the financial person.
Okay. You know, you brought up a point just now about that conversation with a loved one, and maybe it isn't a loved one, but someone you've designated. And I know my mom did this, and she was a nurse. I mean, she worked in the field and she knew the importance of it. But, you know, when they did their advanced planning, they never spoke to any of us about who was designated at anything. And you know, it isn't my decision what should happen. It's really, you know, really being there as their advocate and advocating for what they wish. Can you talk a little bit about what you recommend to your clients about having those conversations? Because it seems to me that's just as important as making sure you've done that.
I forgot one document when I was making my formal remarks. There's something called an ethical will. And an ethical will is not something we're going to find in the Massachusetts law, but it is gaining momentum across the country. The ethical will is something that the individual writes and usually types and usually signs to show that it really was mom or dad that wrote it. And it says why they did what they did. That is a substitute for having a conversation.
Okay. For those that just can't do it.
It is not the first choice. It's for people who say we can't get them all together. I think they'll behave differently if they know everything. I think they'll stop trying if they realize how wealthy I am. It's humorous to me because I attended a lecture by a Boston College professor who said, who taught at Boston College in a planning capacity, it doesn't matter, but this professor said that undergraduates Google their own parents. They know, they can find out a lot about their parents, how much money they have. They can look up certain forms that are filed with the SEC and tell how much their parents are compensated. They know that if they go back from vacation from college in a private jet, it's kind of a tip-off that the parents are very well off. And yet the parents don't feel comfortable telling the children how well off they are. So if it's possible at some point when the children are gathered together and are mature, the parents really should explain what the setup is, even if they don't attach numbers to it at the first meeting, and the numbers can come later. But the strategy, the framework should be described. Your father and I have named XYZ Trust Company. If something happens to us, please contact them. Our lawyer is so-and-so. Our accountant is so-and-so. Our wealth advisor is so-and-so. It should not be mysterious. This is particularly important if there's an unequal distribution among the children or among the grandchildren. Some parents want to give every grandchild a dollar amount on the death of the survivor. So if their children have unequal numbers of children themselves, that is an inequality, which is objected to particularly by a child who has no children,
Mm.
because they feel that their siblings are being rewarded for having had children. But the parent, the client doesn't think that. They think they love each grandchild equally, and it doesn't matter how many siblings that grandchild had. So
Mm.
I've heard both sides of it. Now, that could be explained very nicely in an ethical will,
Yes,
what
yes,
their feelings were.
right. I want to come back to that in a second, but I want to get to other people's questions.
Sure.
It's
Okay.
all about my questions. This question is, if I wanted to make a gift from my estate to a nonprofit organization like Kendal at Home, I didn't ask this question, I promise.
Very good. Very good.
Should I let them know in advance so they know my wishes?
I have seen clients approach this both ways. I feel that making a gift during lifetime is the most rewarding. First of all, you get a double tax benefit because you get an income tax deduction and the asset is out of your estate. So in effect, you're getting an estate tax deduction. You get to see what the organization does with your gift. It's very rewarding. You're invited, you're treated well, you're invited to various events, talks, different things. You can volunteer. Other people feel that if they let the nonprofit know, they will be hounded for the rest of their life for an even greater gift. So I just point out the pros and cons, and I don't really tell people whether to tell them or not. The worst situation is if a client tells the nonprofit and then changes his or her mind and then dies, and the development person comes in afterward and said, I understand we're benefiting here. And the lawyer has to say, oh no, the client changed their mind. So
that would not be good.
And that same problem occurs when you tell the children great detail about what they're likely to inherit, because it may turn out not to be exactly that amount.
Right.
So the concept is good, but maybe not the numbers.
Right. Yeah, it seems to me like this is a whole another topic to bring you back and invite you back to talk a little
Charitable
more about.
planning is fabulous. It's the best, but it is kind of beyond the scope of this.
I think it'd be great to have you come back and talk about that. I want to ask one more question related to that communication, and I didn't ask you about this in advance, because I thought about it when you were talking. If that conversation is sometimes so difficult to have for families, and doing that. Are you familiar with 5 wishes? Have you used that document at all? I know it is considered legal in the state of Massachusetts.
It is?
It is, yes.
Okay, I'm not familiar with it. I'm sorry.
I will send it to you, Mary. I'll send you a link to that, and I can share that with the participants on today's call as well. But it's a document, and we do use it for our members. We provide them with the 5 wishes, but even in Ohio, where it isn't legal, it isn't recognized, you still have to have Ohio's documents completed for your advance directives. It does open up the opportunity for that discussion, and there's actually mechanisms to help promote those discussions. I have a colleague who recently wrote a book about it, just because in her line of work as a physician, she saw that, there were so often those discrepancies where people didn't share with their loved ones. I think I shared with you yesterday when we spoke about, someone who designated, their healthcare power of attorney, who really wasn't able to address the needs that emerged. They were thinking more about end of life issues, not decisions that had to be made for that client throughout her life as she struggled with cognitive impairment and in later dementia. So those conversations are so important and so much a part of what you're talking about for families, and probably can help alleviate a lot of the conflict that I'm sure you see later on after the death. So
It's also helpful to, we have MOLST, MOLST, all caps.
yes,
That would be similar to the 5 wishes. And that's a discussion in conjunction with one's treating physician.
yes.
And that has a lot of influence on later treaters because it was done in conjunction with a physician.
Absolutely.
And I would definitely recommend that, and people do it. And even while we're on this topic, even funeral wishes, burial wishes, those things in Massachusetts, the body belongs to the heirs. It doesn't matter, honestly, what you put in your will. So nobody puts it in their will. So it's very important to discuss with one's next of kin or heirs if there is a burial plot, cremation, not cremation, what kind of service, all that is very helpful to discuss.
Right, right. Okay, I have another question. Is it best to have a lawyer who's not the drafter of the original documents to do the review after 3 years to get a built-in second opinion and hourly fee for the new person to learn my details? I don't know, what's your opinion on that?
If the client is willing to provide the same financial information, the same, not the same, but the same degree. So in other words, to do an estate plan, I have a lengthy questionnaire that I send to the client in advance, and I really don't start on it until I have the questionnaire completed and returned to me. So if I were asked to do a review of someone else's document, I would require that the client filled out my questionnaire at the time of the review so that I have, it's apples and apples.
Right.
And if, of course, if the client had changed his or her idea about the disposition, well, then that would be something else. But if you're saying, is it still in compliance with the law? Generally, I would say the original attorney probably knows you better. And but it doesn't matter. It's not a bad idea to get a second opinion. It's just like medicine. Lawyers don't object to that. They really don't.
Right, right. Mary, thank you so much. I appreciate you taking the time out to be with us today. And I think, Ryan, do you want to just kind of give just a little heads up about the ongoing series that we're going to be introducing in April?
Yeah, absolutely. So coming up next week, next Thursday, starting at noon, we will be having Meredith Sugar on with us. She's a estate attorney out of Columbus with Taft Law. And so she's going to be starting a 3-part series on estate planning. And their first topic is going to be talking about power of attorney. Then next month in May is going to be on the benefits of a trust. And then in June, it's going to be more general estate planning kind of wrap up. But so that's looking to be, we're looking to start a series going forward on the 4th Thursday of each month at noon. So be on the lookout for that. And if you have any questions, feel free to contact us.
Thanks, Ryan. I appreciate it. Thanks again, Mary, for being with us today. And we so much would like to have you back again. So much to talk about in an hour.
Thank you. I seem to have messed up my screen, but it was, I enjoyed talking with you all.
Oh, well, you know what? You're in a perfect view right now. So it's really helpful.
You say so. Okay.
No, it's great. And I think, what's most important is what you shared with us today. And we appreciate that so much. I thank you. And I want to thank all of our guests today as well. So we'll be sure to have send a follow-up link with some of that information on the MOLST and 5 wishes as well for those that might be interested. And again, thanks everybody and have a great weekend. And you guys, I hope you get warm there and that snow melts really quick. Thank you. Bye-bye.